The first main change you saw in 2009 was the implementation of the changes to the Family Medical Leave Act. Uh, these were mostly attempted to be entered in 2008 and it finally passed in 2009. They changed the regulations regarding leave and military caregiver leave. They revised notice provisions and penalties. The notice provisions regarding serious health conditions, medical certification, and fitness for duty requirements. I would think most of you all on this phone call have probably heard of the firm used to be called Morgan, Calling and Gilbert. Now it's called Morgan and Morgan. It's the folks that say they're for the people. You can find them on every ad and TV station and phone book out there. They've been extremely zealous in pursuing wage and hour cases against employers in the state. Matter of fact, they filed more cases than any other firm in the entire country combined. To add to it, they've gotten very excited about the changes to the Family Medical Leave Act, and when they're excited, that means they think they have new ways to sue employers. So this is going to be the hot area of litigation over the next few years. It is very easy to make a mistake with the Family Medical Leave Act revisions because they're as clear as mud, if you ask me. I know some very sophisticated employment lawyers that don't understand them and have a very hard time advising clients on how to comply with them because there's a lot of unanswered questions. There's a famous expression in the law world that when your lawyer tells you you have an interesting question, that means you typically have a very expensive question, and they don't know the answer to it. There are a lot of things that are going to need to be ferreted out by the courts. So again, the changes to the Family Medical Leave Act are going to be very difficult for folks to comply with and be very challenging. Also in late 2009, they expanded military family leave provisions to permit family members of active duty service members to take exigency leave. They expanded military family leave provisions to permit families of certain veterans to take military caregiver leave. They revised the military caregiver leave provision to include serious injuries or illnesses that are the results of pre-existing conditions that were aggravated by service while on active duty. I know a lot of people thought when the administration came in that at least 2 wars abroad right now would probably wind down. If you read the newspaper, that doesn't seem to be the case, in particular with Afghanistan. We're sending a lot more service members over there. So I think the provisions regarding military leave are going to continue to be extremely important because it doesn't look like we're going to be done fighting in foreign lands anytime soon. In 2010, there are a number of potential changes. Labor unions and the Department of Labor have been pressing very hard to make some changes. One interesting tidbit is when the Family Medical Leave Act originally came into play in the early 90s, if you look at the congressional record, the folks that were promoting and prompting the passing of the Family Medical Leave Act swore up and down that they would never try to turn the Family Medical Leave Act into what I call European-style leave, which means it's guaranteed paid leave. Right now, obviously, the Family Medical Leave Act is unpaid leave. Well, that's one of the hot issues out there. There are some states that have already gone to it. I think Maryland's one of them, where if somebody takes what is called FMLA, or Family Medical Leave, in Maryland, for instance, under their state statute, it's paid leave. So in essence, you have to give folks paid vacation. That's one of the hot issues out right now that's being debated in Congress. Other changes that may take place with FMLA is DOL, the Department of Labor, states it will review regulations implementing military family leave amendments as well as those implemented in 2009. And they talk about regulatory alternatives will be developed. I have found that every time the Department of Labor or any lawmaker intends to clarify or expand a law, rarely is it clarified, but it's always expanded. I can't think of any time in my career in which a law has been pared down to give employees or plaintiffs less rights. So all I can tell you is that it will be expanded, not reduced. One HR 2161, which is called the FMLA Restoration Act, introduced to repeal certain regulations and reinstate earlier regulations. In the earlier FMLA regulations, there were certain penalties for not doing proper notices or giving proper certification within a certain time period. That will probably come back in if this passes, and there will be far more penalties for employers. There are a number of other bills out there that would revise the FMLA that was introduced in 2009, which include the following. FMLA Inclusion Act, which permit leave to care for same-sex spouses. domestic partners, parents-in-laws, adults, children, sibling, or grandparents. The main area right there is dealing with same-sex couples or domestic partners. I will tell you, if I'm going to read the tea leaves, I will tell you that at some point in time, this country seems to be trending towards more protections for sexual orientation in same-sex couples. Obviously, that's going to get even more complicated if folks are just living together. You're going to have to inquire if they're truly domestic partners or just roommates, but it's going to make it far more complicated. What I do think eventually will happen is there'll be far more protections for sexual orientation. Many states as well as cities and counties already have such protections out there, so it's just a matter of time before it comes to your site soon. Also, the Leave Enhancement Act would include parental involvement leave, attending children and grandchildren's educational and extracurricular activities, taking care of routine family needs, and assist elderly relatives. So what this is seeking to do is if somebody comes to you and says, hey, I want to go to a parent-teacher conference, or I want to attend little Johnny's baseball game, they're trying to make that part of the Family Medical Leave Act. I'm not so sure that one will pass, but it's possible. Also, the Military Act of 2009 give 2 weeks of unpaid leave to employees whose family members have received notification of impending active military leave. This is one I think that will probably pass, regardless of what side of the political aisle you are on. Most politicians don't want to be on record voting against some sort of benefit for those who serve in our armed services. So that's probably going to pass. There's the Domestic Violence Leave Act, allow employees to take leave to address issues arising out of domestic and sexual assaults. Florida's got a provision regarding this already, and many cities do as well. That most likely will be passed. Again, that's another thing people, congressmen and politicians as a whole, don't typically like to be on record of opposing leave for domestic violence issues. It makes for very bad fodder for them during campaigning, so that's something that will probably get passed. Other legislation relating to employee leaves but not amending the FMLA were introduced in 2009, and they include the following. Family Friendly Workplace Act provides employees with compensatory time off. That's about very similar to the provision I talked earlier, where you're going to have to give people paid time off to spend time with their families. The Security and Financial Empowerment Act permits victims of domestic violence, dating violence, sexual assault, or stalking to take up to 30 days of unpaid leave in a 12-month period for issues relating to violence, prohibit employers from discriminating against actual or perceived victims of such violence. We don't know, obviously this hasn't been passed, so we don't know how big of employers will be affected by this. Right now, obviously, in the Family Medical Leave Act, you need at least 50 employees. I wouldn't be surprised if this law passed that they would move it down to employers as small as 15 employees. So just about everybody would be covered by this provision or this law if it's passed. The Health Families Act requires certain employers to permit each employee to earn at least 1 hour of paid sick time for every 30 hours worked. So again, that's another way to try to get to the same place of mandatory paid time off. There's the Working Families Flexibility Act, permits employees to request once every 12 months that employers modify their work hours, schedules, or locations. You can imagine what sort of scheduling nightmares that would be for you all if that passes.